Hello everybody. So today we are going to discuss the constitutional position of governor with respect to CM. So what is the constitutional envisioning of governor's power? What is, whether he is nominal head, whether he is executive head, whether he is de facto head, whether he is de jure, why he is called titular head, why he is called nominal head. So all those kind of questions will be responded in this video. Prior to this we already have released another video. So if you have not seen that, I'll urge you to watch that video before entering into this video. So in the first video we had discussed about the qualification, appointment, how this governor's office came into existence, how this governor office draws its roots from Government of India Act 1919 and 1935. So all those discussion we had in the first video. In the second video we had wide amount of discussion on executive power, legislative power, judicial power and financial powers of the governor, how it draws its equivalence between the powers of the governor to the powers of president. So all those discussion we already have in the previous two video, and this is the third part in the continuation of our discussion on the governor, and hopefully we'll be wrapping up this lecture in the third part. But if you recommend and if you point out that there is any topic that remains pending, we can have a separate video that will be fourth video, and we can cater to that topic as well. So with that declaration, let us move to the next slide and let us start discussing that what will be the contours of this video. So we'll limit our discussion in this video on these topics. So what is the constitutional position of the governor? So it has been defined in Article 154 and Article 163, that actually these two articles actually defines the relationship between Chief Minister and the governor as well. Then we'll discuss what is the discretionary power of the governor, how the discretionary power of the governor is different from discretionary power of the president. So if you remember, when we were having discussion on the president's discretionary power, we had this discussion that the president does have little amount of constitutional discretion, but he does have some amount of situational discretion. As far as governor office is concerned, you will notice that he does have constitutional discretion as well and situational discretion as well, and that is the reason that why governor's discretionary power is called wider than the presidential discretionary power as well. And there is another reason why the governor's discretionary power has been declared wider than the presidential discretionary power. So in the second leg we'll have a discussion on that. Finally, what is the problems with the discretionary power? We have put up few recent case study and past case study as well. So we'll take up example of Maharashtra cabinet recommending this nomination of Chief Minister Uddhav Thackeray to the Legislative Council, and Maharashtra governor delaying that until there was political settlement at the central and state level, which should not have happened. Generally the practice has been that the cabinet generally recommends for the nomination to the Legislative Council. Cabinet recommends the member, and thereafter on the basis of recommendation that has been sent by the cabinet to the governor, governor nominates member in the Legislative Council. If you remember, in the previous video we had discussed that governor does have power to nominate 1/12 of the number of members of the Legislative Council through the method of nomination. So this nomination that happens, that is on the recommendation of cabinet headed by Chief Minister, right? So that has been the practice. But this, in case of Maharashtra recently, when Uddhav Thackeray's nomination was recommended by cabinet, there was huge amount of delay, and rather the position of Chief Minister, means Uddhav Thackeray, was endangered because of this delay. But ultimately there was settlement at the political level. Then recommendation of various committees and commissions. So if you remember, in the first video we had discussion that how central government does have huge amount of control over the term and the appointment method, and it is because of these two factors, control over term and control over appointment, that governor's office does not function independently. They can't function by the fear of their term being reduced, or they can be terminated at any time at the whims and fancies of central government, right? Or they cannot be appointed without the central government support. So it is because of this reason that you will see that various committees and commission over a period of time, first Administrative Reform Commission, then Rajmanar Commission, then you have this Sarkaria Commission on the center-state relationship, then you had this National Commission on Review of Constitution, that was Venkachalaya Commission. Then you had this Punchi Commission. So what kind of recommendation that they have given with respect to the independent functioning, means how their term and appointment method can be changed so that governors can function independently, so that they can function in a fearless manner, right? So all those recommendations we have put up on the slide. So we'll have a discussion on these lines, right? So, and the last portion, as usual, we have put up 4 or 5 MCQ for you to attempt. So I hope these contours of this lecture would be understood. Let us start discussing the position of governor with respect to the chief minister. So in the previous slide, when we were discussing the video, when we were discussing the executive position or executive power, legislative power, or financial power or judicial power of the governor, there we had this slide, and this slide is nothing but a snapshot from the previous video, right? So there we had declared that this person, governor, will be called head of state, and this chief minister will be called head of government. He will be called titular head, he will be called nominal head, he will be called that he wields symbolic power, he will be called ceremonial head, but this person, he will be called de facto head, means real head. He will wield real power, but that is nothing, means when we were calling that he is head of government, he will be head of state, he will be holding symbolic power, he will be holding real power. So these things are nothing, these things are sweeping conclusion, right? We need to see that where in the constitution these points has been mentioned, that a real power will lie with the chief minister, while he will be only symbolic, he will wield only symbolic power. So there are 2 articles that mention these things, that chief minister of the state will be real head, and those 2 articles are article 154 and article 163. So when we'll have discussion on article 154, in the next slide we have means put up these 2 slides for discussion on these articles. So you will see when we'll have discussion on article 154, this article 154 says that all the executive power shall be vested in governor. So it is nothing but a declaration that he will be head of state. But in the article 163, you will see that the executive power that has been vested in this office of governor, that will be actually exercised by support of council of minister headed by chief minister. So that is nothing but declaration of that he is the head of government, he does have real power. All the decision will be taken in his name, but decision will be taken actually by this person, chief minister or council of minister, right? So that is a declaration that he will have real power, he will be only nominal head, right? So if you remember, when we were having discussion on the president and prime minister relationship, we had these 2 articles in discussion, article 53 and article 74. So article 53, you can draw equivalence from article 154, and article 74 was nothing but you can draw equivalence of article 74 from article 163. So article 53 similarly had said that president will be executive head of the union, all the executive power of the union will lie in the office of this president, and article 74 was actually defining the relationship between chief minister and prime minister and president. So in article 74, if you remember, the language was that there shall always be council of minister to aid and advise president in exercise of his executive function, right? So article 53 and article 74 are 2 equivalents of article 154 and article 163 at the state level. These 2 articles defines the relationship between prime minister and president, and these 2 article 154 and article 163 defines the relationship between chief minister and executive. So these articles at the central level and these 2 articles at the state level are going to be very important, and these 2 articles you must remember. So let us have a discussion on article 154. So article 154, as I told you, that this is a equivalent of article 53 at the central level, and we had this wide amount of discussion on article 53, and language of article 154 is almost similar to article 53, except that the words have changed. Instead of president in article 53, you have this governor in article 154, otherwise everything remains same. So we'll break up this article 154 in 2 parts for our better understanding. So what is this 2 parts? So first part is from here to here. So what does this first part say? The first part says the executive power of the state shall be vested in the governor. So he'll be executive head, but mind you, this governor is just a formal executive head. He is not a real executive head. And where is the declaration that he is just a formal executive head? We'll see that, right? Then the first part says that okay, executive power of the state shall be vested in the office of governor. Then in the second line, if you see, is that it shall be exercised by him either directly, right? So the keyword is that this power, this executive power that has been vested in the governor's office, that can be exercised by him directly or through officer subordinate, right? So let us stop here, let us have a discussion on this. So it says that yes, executive power has been vested in the office of this governor, and this executive power can be exercised either directly or through officer subordinate, right? So if we stop here, you can deduce the meaning that hey, governor might say, he can be autocratic at times, and he might say that no, I am not sharing power with anyone, I want to exercise this executive power directly. In that case, he will not remain nominal head, he will become real head, isn't it, right? So why are you calling him a nominal head? He is actually real head in case if he decides to exercise this executive power directly. But there is this third line, and third line circumscribes him from directly exercising this executive power, because the third line says that he should exercise this power in accordance with the constitution. And what does the constitution says about this? So the constitution says about this in article 163. When we'll have discussion on article 163 in next slide, you will see that it says that there should be council of minister headed by chief minister. So you will have this chief minister who will be heading this council of minister. So there shall be council of minister headed by CM to aid and advise governor in exercise of this executive power, in his exercise. So he'll be exercising this executive power. All the decision will be taken by this governor, but there will be council of minister headed by CM who will advise. So all the decision, now understand the meaning of this real power and the formal power. Now understand the meaning of de facto head and the de jure head. So yes, all the powers will be exercised in his name, all the contractual obligation will be taken or will be written in his name, all the agreements with another state, all the contractual obligation, all the contractual work that state may be indulging in with some private trading body, with some private contractor in the road construction sector or any area. So if state is signing any kind of MOU, if state is signing any kind of agreement, so that will be signed in governor's name, and that's why he has been called that he will be formal executive. But who will take all the decision, that which contractor to bring in, how this method of trading will happen, right? So what will be the terms of agreement, what will be the terms of contract, that will be ultimately decided by this council of minister headed by CM, that we'll have a discussion on in article 163. So when these people are taking all the decisions, so these people are the real head council of minister. They are advising the governor that hey, you do this, you take this decision, you do this in this manner, right? So that is the declaration. I hope by breaking up this article 154 in 3 parts, I would have been able to convey you the real meaning of article 154. And mind you, this article 154 should never be read, right, the way we connected this article 154 with article 163, that is in next slide, right? So this is the way, article 164, right? So that is the way, just a moment, this should be article 163, I guess, just a moment. Okay. This should have been article 160. So my point was that the way we connected this article 154 from article 163, this is the way that how you should be reading these articles. So I hope you will have clarity on, although we are going to discuss this article 163, but we already have discussion, but let us have this discussion on article 163 as well. So this article 163 says that there shall be council of minister with the chief minister. So let us have a pictorial representation. So it says that there shall be council of minister with chief minister as its head, right? So if you remember article 74, in article 74 as well, we had this similar image, similar kind of structures, where you had this Modi as prime minister and there were other minister who was forming the part of council of minister, and there you had this Ramnath Kovind acting as president, and the difference was only this article was 74 there. So that is the thing, and that is what I was talking about, the similarity that we do have article 163 drawing similarity from article 74. So it reads that there shall be council of minister headed by chief minister to aid and advise, whom? To aid and advise this governor in the exercise of his function. Which function it is talking about? The executive function that we read in article 154. So there shall be, let us read it in entirety. There shall be council of minister with the chief minister at the head, right? He will be head, this chief minister will be head of council of minister. So with the chief minister at the head to aid and advise the governor in the exercise of function that has been mentioned in article 154, right? So this is the first part. Now there is a difference between article 74 and article 163, and the difference here again, the thing that I was talking about, the discretionary power of governor is larger than the discretionary power of the president. This second portion is going to define that why the discretionary power of the governor has been called the larger than the discretionary power of the president. So if you remember article 74, this is the snapshot from the article 74 from the president's lecture. So it read that, okay, the first portion of this article 74 was almost similar, right? Almost, you will see the parallel. So it says that there shall be council of minister with the prime minister as its head to aid and advise the president. So until this president and until this governor, every word is same except that it has been replaced, just president has been replaced with the governor. So up to this point things are almost same, but thereafter things changes, and the things changes in presidential perspective, that who shall in exercise of his function act in accordance with the such advice. So whatever advice that is being tendered by the council of minister at the central level, president will have to act in accordance with the advice, except the one exception. That exception I am not going to discuss. I hope that you already know the exception, that he can send, the president can send that advice once for the reconsideration, but even after the reconsideration, unchanged reconsideration, if the same advice is sent to the president will have no other way than to agreeing to that advice, than to paying heed to that advice, be it in regards to some policy matter, be it in regards to some implementation of president emergency or imposition of national emergency, or any kind of advice that may be, right? So president can at just once he can send this recommendation sent by cabinet for reconsideration, thereafter president will have no option. But that kind of, the limitation that was imposed on the powers of the president in the article 74 by 42nd amendment by Madam Gandhi in 1976, that kind of limitation has not been put up on the governor's power by any kind of amendment. So governor, so here is the difference, that it says that in exercise of function, except so far, so yes, council of minister, whatever advice that council of minister is tendering to the governor, he will heed to that advice, but only to the extent that he feels necessary, right? If he feels that there is any activity that he shall, or there is any policy matter that he shall exercise his discretion upon, then he can exercise this discretion, right? So and that's why, that is the reason that president's discretionary power has been called that president does have very small amount of discretionary power, but governor does have wide amount of discretionary power, right? Because of this line, this limitation that was imposed by 42nd Amendment to the president, that kind of limitation has not been imposed on the powers of the governor, right? So whatever area that governor wants to have discretion on, those area governor can have his discretion. That's why again I am repeating that the governor's discretion has been called larger than the presidential discretion, right? So what is the discretionary power of the governor will be decided by the governor himself, right? So if he says that these all areas are my discretionary power, constitutionally you cannot stop them, right? Although there has been cases wherever this governor in any state has tried to act in an arbitrary manner as far as exercise of his discretionary power is concerned, there has been cases that has been dragged into the Supreme Court by various council of ministers of different state, and the Supreme Court has done the justice. But as far as means those has been done by the intervention of the Supreme Court, but as far as constitutional position, let me tell you, is concerned, there has not been any amendment the way amendment was done by in presidential power. So presidential power has been circumscribed by article 42nd amendment in IT. So that kind of amendment has not been done in regards to the governor's power in the constitution. So constitutional position still remains that the discretionary power will be decided. What is the discretionary power of the governor? That will be decided by the governor himself. Again I am repeating that yes, this does not mean that he'll do or he'll act in any manner, right? He can act anything arbitrarily and that will be tolerated. No, there has been cases where cases has been dragged whenever a governor has tried to act in an unreasonable manner. You have this activist judiciary, especially in last 20 years. Judiciary means after 1980 or 1985, if you see the decisions of the judiciary, you have this active phase of judiciary. Judiciary has got this thing I forgot to discuss in the Supreme Court. So union judiciary has gone through various phases. It has, for some time it has remained submissive, for some time it remained passive, then it has gone to the active phase. So the right now the phase that is going on for the union judiciary, that is a phase, active phase of judiciary, where it is exercising this article 142 very liberally. It is applying those articles for sake of natural justice. It is applying article 142 in a very liberal manner, and that's why I am calling that judiciary is very active at this moment. So any case of arbitration, even means whenever even during government formation or invitation, when it sent by governor in what you call arbitrary function, you will see that the cases land in the governor. Whenever there has been any recommendation by the governor, any kind of act of the governor that has seemingly favored the ruling party at the center, right, you will see cases landing in the Supreme Court. So yes, Supreme Court has at times circumscribed the powers of the governor, right, by various decisions, but as far as constitutional position is concerned, I am again repeating myself that the discretionary power of the governor will be decided ultimately by the governor itself, and that's why discretionary power of governor has been said that it is larger than the president, because president does not, if you remember in the previous slide we had declared that he does have little amount, or rather no amount of constitutional discretion, but he do have whatever little discretion that he does have is only situational, especially when you have Lok Sabha which is in hung position, right? No party has been able to secure the clear majority only then, and there is one or two other situation when we had discussion on the president, we had discussion on this situational discretion as well. So I hope why discretionary power and article 154, article 163, how this article 153 and article 163, article 154 and article 163 draws its parallel from article 53 and article 74. These all points would be clear to you, right? And what is the constitutional position of governor with respect to CM, all these things would be clear to you. Now we are moving to the next slide. to discuss the types of discretion that is available to governor. So there are actually 3 classes of discretion that is available to the governor, but here we are discussing only 2. The third area in which governor does have discretion will have a separate discussion, but in this video itself. So these are the 2 types of discretion, 2 classes of discretion that governor does have. So these are constitutional discretion and the situational discretion. So these are the area of constitutional discretion. Means what is the meaning of constitution? What is the meaning of first of all discretion? So the meaning of discretion is that in all the area, on all these area that we'll have a discussion on, right, governor if wants, he can act without the advice of council of minister. If you remember article 163, the first portion of article 163 says that there shall be council of minister to aid and advise governor in exercise of his function, right. So generally he will act with the aid and advice of the council of minister headed by chief minister, but there are certain areas that he can exercise his discretion on. So these are the constitutional discretion. Means what is the meaning of constitutional discretion? So these discretion has been mentioned in the constitution, that regarding these areas that you see, regarding these 5 area, in these 5 area, when decision has to be taken by the governor, he, if in his opinion he wants, right, he can take these decisions on these matters independently. He need not to have handicapped by the decisions, by the suggestions of council of ministers. So what are these 5 areas? So first, if you see, while reserving any bill for presidential assent. So if in opinion, in the second video, if you remember, right, we had categorized 3 kind of bill in 3 categories. So in the first category, if you remember, there were certain kind of bill which needed approval of president even prior to the introduction in the house. So that was the first category. In the second category, if you remember, if when a bill passed by state legislature is sent to the governor, there were 2 kind of bill, 2 categorization. The first categorization was that if in governor's opinion, if any bill was violating fundamental rights, if any bill was violating DPSP, if any bill was not in larger interest of the country, or if any bill was clashing with the central laws, so in that case governor can reserve that bill for the presidential assent. Then in the third categorization, if you remember, there were 2 category of bill or 2 classes of bill which governor will have to necessarily reserve for the assent of president, and that was in cases of financial emergency, a money bill if sought by the president, governor will have no option but he will have to reserve the bill for the president. And the second class was that when you had this any kind of bill passed by state legislature or any ordinance passed by the state legislature which was endangering the position of the high court, even in that case governor will have to mandatorily reserve that bill for the presidential assent. So while deciding that which bill should be kept for the presidential assent and which bill should be, means I can directly sign as a governor, right, governor will not have this advice in regard to this area. Governor will not seek advice of council of minister headed by CM. He'll take the decision on the reservation of the bill for the by the president, right. So that decision will be taken by him independently. The second area is that the president rule recommendation, this article 355. So whenever governor feels that state government has virtually collapsed and there is no other way that the state government can run on the constitutional line, then that decision, that whether president's rule should be imposed or not, that decision too he will take independently. He need not to go to the council of minister to ask, hey, I am collapsing your government, right, I am I am dissolving your government, right. So that decision he'll take independently, because why on earth any elected government will suggest governor to impose president's rule in the state, because ultimately that will be lost of the power to the elected government. So in that area as well, when governor has to write a recommendation to the president for the imposition of president rule, you will find that governor will take independent decision, independent of the council of ministers advice. Then the third area is that while determining the amount payable to the autonomous tribal council, so you had these 4 states, Assam, Meghalaya, Tripura and Mizoram. So for these 4 states, means these are minerally rich states in the northeast especially, so state government does extraction. So there are tribal advisory, this autonomous tribal council, right? So they are, when we'll have this fifth and sixth schedule discussion on, right, you will find what is this tribal advisory council, what is this autonomous tribal council, right? So there is something called autonomous tribal. As of now, just you have to keep this in mind, that there is something called autonomous tribal council in these 4 states, right? So what amount that should be given by the state government in lieu of the extraction, mineral extraction that is being done by the state government to these council, autonomous tribal council, that will be determined by governor, and that decision governor will take independent of the council of minister. I hope this third point would be clear. Then the fourth point is that while exercising the functions as administrator of adjoining UT. So you had this Punjab governor who does have additional responsibility of Chandigarh as well. So whatever decision, means he is administrator of Chandigarh as well, that he has been appointed that function, that additional function had been given to him by the president. So whatever decision that he has to take in regards to the Chandigarh, he will take the decision independent of Punjab's Council of Ministers advice. I hope that point also would be clear. Then the fifth area, seeking any information from chief minister or council of minister regarding the administration, that how they are running this administration. So that at times may be embarrassing for council of minister, because that function he will exercise. So you may have seen in the president lecture, if you remember, we had discussion that opposition party often keeps meeting president to issue issues like the Shaheen Bagh, to issue the discussion on NRC, to have discussion on that how the Chinese incursion has been handled poorly by the government. So if the opposition delegation has met president and president assume that yes, or the governor at the state level, if governor feels at the state level that yes, whatever points that opposition delegation of this opposition has raised validly, so those points, information on those points, governor can ask from the council of minister, irrespective of कि council of minister क्या feel करने जा रहे हैं. अगर ये चीजें मीडिया में आ गई तो it may lead to embarrassment to the government, right? So that decision on that question asking or that information seeking will be taken by the governor independent of council of minister. So these are the constitutional discretion that has been given to the governor. Now let us discuss what are the situational discretion that has been given to the governor. So this situational discretion is almost similar to the presidential discretion in these situations. So if you remember, while we were discussing on the presidential discretion, we had clearly said that there are certain situations. So when assembly is hung, means no party has been able to secure express clear majority, and there has not been, means post poll alliance also is not being formed. So in that case, or even if post poll alliance has been formed, governor at the state level and president at the central level will have power that who he find ki stability कौन दे सकता है, whether a post poll alliance is in condition to give stability, or single largest party can give what you call stability, a stable government for 5 years. So that decision has to be taken by the wisdom of governor at the state level. So appointment of chief minister when no party has express majority, no other party. So it may be a situation where suppose 288 seat, if Maharashtra example, if you remember Maharashtra example I had taken. So Maharashtra does have 288 seats, and a party which wants to form government, that party needs to have this 145 seat, but no party in Maharashtra case was able to secure this 145 numbers. The largest party was BJP, which was able to secure 105 seats, and there was coalition from Shiv Sena, NCP and INC, Indian National Congress, right? So they collectively would have, means I don't exactly remember, but their collective seat crossed 150 rather, right? So that they are, now it is the decision that has to be taken by the governor whether following the convention, this particular party, the single largest party, the established political convention dictates that the sequence should be that the single largest party should be called first, single largest party, then if there is any post poll alliance, that will be called, and thereafter the smaller party in sequential manner will be called. So that is the order. But if governor at the state level and if president at the central level feels that no, post poll alliance is able to give a stable government for next 5 years, then governor can take the call that no, this post poll alliance, the single largest party should be ignored, and the post poll alliance party should be called to form the government. So that is first situational discretion, that which party should be called, which leader should be sworn in as CM, chief minister, in case no party has been able to secure the majority, and thereafter a reasonable time will be given, right? 2 days, 4 days, depending on the political situation, that time will be decided by the governor. And this discretion comes, we are discussing all these topics under the discretionary power of the governor. So this discretion this discretion is called situational discretion of the governor. The next situation, so dismissal of COM, council of minister, when it has lost no confidence. So generally the practice is that whenever council of minister goes for the any no confidence motion has been moved, or if governor has suggested कि आप house में मुझे, in my opinion, you are running a minority government and you should go to the floor of the house and seek the confidence of the house, right? So in these two situations, if the council of minister does not secure that majority mark, if they do not have this confidence of the house, so in that case council of ministers generally chief minister will come, and on the basis of on the behalf of council of minister he will submit the resignation. So that has been the practice, but at times it may be, although such situation has never occurred, but at times you will find that council of minister may act in an arbitrary, unjust way, and they might say no, we are not resigning, right? So in that case governor has been given power that he can dissolve or he can dismiss that council of minister in a forceful manner if they are not following the established political convention and if they are not willingly resigning, right? So I hope this second point would be clear. Then third point, when council of minister in fear of losing, so let us understand this third point. So suppose there is a government, there is a stable government that is running from last 2 means general term is 5 years, so they are running from last 2 years in a good way, right? They do have majority and they are running, they have formed the government and everything is good, right? But there may be situation that suppose 2 years down the line and 2.5 years down the line, due to defection, suppose 10 or 15 MLA of that particular party defected to some other party, or they withdraw their support from council of minister or the government, and they have given a clear indication that we do not have any confidence, although they belong to the same party, that they have given a clear indication through media or any channel that we do not. So in that situation, either due to opposition pressure or governor can take the decision suo moto as well. So what governor can do, either under again opposition's pressure or suo moto, what he can do, he can suggest the government, hey, you go to the house and seek the confidence of the house. Now the council of minister headed by this chief minister, what they can do in such situation, that fearing, they already know that yes, we do not have number, so in that case council of minister can suggest that hey governor, you do one thing, you dissolve this house, right? Generally council of minister, whatever council of minister, when they do have majority, in that case whatever advice that is tendered by the council of minister, that is followed by the governor. But in case if governor feels that this guy, council of minister, is suggesting me to dissolve the house because they fear that they would not be able to face the floor, they will not be able to secure the majority on the house. So for the fear of being defeated on the floor of the house, if they are recommending me to dissolve the house, so in that case governor will not consider the advice of council of ministers. So this third point would also be clear, dissolving the house when no party has been able to form the majorities, to secure the majority. So again I'll take Maharashtra example. So in Maharashtra you had these 4 or 5 parties, A, B, C, D, let us describe. So governor called this party A, they said no, we do not have number. B, no number. C said no numbers. D, no numbers. E, no number. Thereafter he sat with 2 similarly ideologically close party and suggested them, hey, can you form the government by the coalition? They said no, means हमारी seat sharing ऐसी नहीं हो रही, we cannot form the government. So whatever possibility that could have been explored by the governor, he or she has already explored, right? Thereafter exploring, in Maharashtra case, president rule was imposed for a certain day, right? After 10 or 15 days, INC, Shiv Sena and NCP came together and they said that okay, we are going to form the government. So this president rule was lifted, and rather not president rule was lifted. There is sequence of event we'll discuss when we'll discuss this Maharashtra example. So as of now, means after exploring all the option, he'll impose the president rule. He'll wait for a certain number of days, for 2 months or 3 months. After 2, 3 months or 4 months, rather maximum of 6 months, he'll wait. And after 6 months, if we see no possibility of government formation either by coalition or by any party, then he can dissolve the assembly, right? And he can seek by ask Election Commission of India, yeah, fresh election karwaye jaye, right? So these are 4 are the situational discretion of the governor. I hope this point would be clear. This Maharashtra example, why I abruptly left, because we have to understand this in next slides, right? So that's why I abruptly left. There is one more class, or there is one more area where governor does have what you call discretion, and although generally in this particular area we'll have what particular area I am talking about, right? So we'll have a discussion, but in this particular area or in this particular category, he'll seek the advice of Council of Ministers, but the decision, the final decision will be taken by him only. So what is those area? So these are 8 are the state, 3 on the western coast, Gujarat, Maharashtra, just a moment. So these 3 states on the western coast, Gujarat, Maharashtra and Karnataka, and 5 out of this 7 sister states, rather this including the CM, it will be 8, right? So 5 out of this 8 northeastern state, except Meghalaya, Tripura and Mizoram, these 5 states, so 5 NE and 3 at the western Ghats, right? So these 8 states, so certain regions of these like Vidarbha, Marathwada, then Saurashtra and Kutch, right? So certain, and similarly these states as well. These 2 states, some part of these state and some part of these state does have certain special situation. So these states are very poor, economically backward, not states actually, these regions, Vidarbha and Marathwada, then Saurashtra and Kutch, right? They are very economically backward, these particular region. So governors in these states have been given special responsibility by the president कि इसको थोड़ा अच्छे, इस areas को जो है वो आपको थोड़ा सा अच्छे से देखना है. So governor does have certain special responsibility. Similarly, if you go to the northeastern states, right, these people in Nagaland, these people in Meghalaya does have certain special condition. They do have certain special customs, and the protection of the preservation of those customs are necessary. अगर उस पे आप ये जो पार्लियामेंट के laws हैं या स्टेट के law हैं वो uniformly means what parliamentary law that you are applying in Madhya Pradesh and Uttar Pradesh, if similar criminal laws or similar or civil laws if you apply in these states, then there will be ruckus, there will be rebellion, right? Because they do have special, means they still have aboriginal tribes and they will not accept these kind. So again, for the preservation of their custom, for the preservation of their practices, it is necessary. So in that regard as well, president has given governor of these state for the protection of those tribals, right? When again I am saying that when we'll have this 5th and 6th schedule, right, we'll have a detailed discussion on this, that what are the special needs when we'll study tribal advisory council, why autonomous tribal council has been established in these states, right? So we'll have, so considering the economic backwardness of particular regions, particular pockets in these states, and for the protection and preservation of the custom and special practices, their special culture on these part, these 5 plus 3. So in regard to these 8 states, certain special power has been given to the governor, and the decision regarding that what funds should be allocated to this area, what laws will apply to this area, or what funds should be allocated for that particular pocket in Maharashtra, Gujarat, Karnataka, right? So that decision will be taken again, not independently. Here Council of Ministers advice will be taken by the governor, but if there is a conflicting situation between the governor's opinion and Council of Ministers opinion, then governor's opinion will prevail. So you can put this governor's power regarding these state, these 8 states again in the discretionary power of the governor. So I hope this discretionary power of the governor would be clear to you, that this is economic backwardness, due to economic backwardness or due to for the preservation of unique social practices and administration of tribal areas. So we already have discussed. So I hope this discretionary power of the governor would be clear to you. Now let us discuss what is the problems with the discretionary power of the governor. So if you remember, in the previous video, second video on the discussion of our governor, we had this extensive discussion on the legislative power, executive power, financial power and judicial powers of the governor, and there is no contention on this particular area. It is a well accepted practice that Council of Ministers advise governors in these particular area, and on the advice of Council of Ministers, governors have acted in that way, right? Except the veto power that governor has been equipped with in legislative domain, there is no problem as such, except there may be rare cases here and there, but this is a well accepted practice that Council of Ministers will advise, and governors have acted in that way. But problem arises in this discretionary power of the president, especially this situational discretion. So if you want to see what are the field, especially in this situational discretion where problems occur between central state or governor and Council of Ministers advice, so these are the area. So whenever you have this hung assembly cases, you will see that power of appointing chief minister that we discussed in the previous slide, power of appointing or swearing in this chief minister belongs to this governor. He is Bhagat Singh Koshyari, currently governor of Maharashtra. So because of this discretionary power that this man has been given, and mind you, this person does have, means governor's office is being controlled by center through control and on term plus appointment. So because of these two reasons, you will find that the decision that is taken generally or most of the time are based on political consideration, and these decisions seems to be favoring generally the central ruling party, the ruling party which is acting in center. Then the second area is power to recommend president rule, article 356. So here as well you will see that on the convenience, on the expediency, means most of the time, if you remember emergency lecture when we had discussion on, so 1977 and in 1979 were the very landmark year as far as forceful emergency evocation on certain state. So if you remember, 8 states were suspended in 1977 by Janta government, 1977, yes, 1977 by the Janta government, state government, and 1979 when Madam Gandhi returned to the power, so same 9 state was again state government were suspended using this article 356, and there has been major case, another cases as well for the evocation of this article 356. So these are also generally done on this political expediency of the ruling party in the center. So this is the second area, this is the second bone of contention, where state government, elected state governments are not taken into the confidence, and even after having chances of the state government survival, this article 356 is imposed. Although again I'll emphasize that this with active judiciary phase, these cases have come down, but still there have been committees and commission, you will see, that have recommended कि 356 में जो powers governor को sweeping powers दी गई हैं, those sweeping powers should be moderated. Then third area, power to dissolve the assembly. So if you remember, again on the previous slide we had discussed that in certain cases, even after, you will see, means post independent political history, if you would have read right, at the central level, one incidents came to my mind where Charan Singh in 1980 had not been given chance, means he had time, not Charan Singh, on the recommendation rather of Charan Singh, right, Lok Sabha had been dissolved and the other party, other leader had not been given sufficient time. He was asking that give me time, and that was not, means that is not of governor example, that is of president example. Right, so this happens at the state level as well, that even when there is chance that the what you call opposition party can form the government, they just need time of 15 days or 20 days to have negotiation between different party, but those time is not given by the governor if the parties in the state are not favorable to the interest of ruling party in the center, right? So these are the three contentious areas where governor's decisions seems to be favoring center at times. Let us see what are the incidences, recent cases of power of abuse by the governor. So recently, just this is a news of, if you see, 29th of April, right? We are in June. This is a news of 29th, and this slugfest almost went whole of the May, right? So this is a news of 29. So what is the incidence? So here governor, as you know, governor does have power that he can nominate 1/12 of the member to the legislative council. Generally, the accepted practice is that he does recommend the names of the person for the nomination into the legislative council on the advice of council of minister. Now, if you know, the Uddhav Thackeray, when he was sworn in as chief minister, he was not MLA. By rule, he is supposed to be MLA in the 6 months. Now, assembly seat koi khali nahi thi, so there was obvious that he had to come by this legislative council. Now, when the election for this legislative council was supposed to happen, that election was postponed by the ECI, Election Commission, due to the lockdown and this COVID crisis, right? And इस बीच में ये 6 महीने का जो 6 months का period है, the 6 months period was getting over. Now, it is not his mistake, means scheduled election for the legislative council, if had been conducted in time by the ECI, then he would have been elected surely, right? Because he does have support of NCP, he does have support at the political level of INC and his own party. So he would have surely entered into the legislative council by the process of election. But it is not his mistake. This is extraordinary circumstances, right? ECI has deferred the election on account of this lockdown and COVID, right? So somebody should own up the responsibility. Okay, there was another way. The another way was that there were 2 seats which were lying vacant, and that could be filled by method of nomination. Now, COM, Council of Minister, sent the advice to the governor that, hey governor, you please appoint this fellow Uddhav Thackeray, nominate this fellow Uddhav Thackeray into the legislative council. Now this person, governor, kept delaying this appointment, this nomination, and until the day, means this 6 months was about to complete in 10 days or 15 days, I don't exactly remember the number of days, until this particular 10 or 15, when he came completely closed, he was rather signaled by the ruling party at the center that until you settle the few points at the political level from the prime minister, that is opposition party. In the state level, BJP is the opposition party. Again, I am giving you the caveat that I am using political example. This caveat has been issued earlier as well, that these kind of political examples should never ever, means these kind of allusion, if you are casting any kind of aspersion in the exam, you need to just allude towards that incident. That's sufficient. Examiner, some kind of brilliancy, some kind of wisdom you can expect from examiner as well, that he do understand, right? So you just need to allude about the incident and that would be clear. So you have to diplomatically, you can state few things, but you will have to state those things diplomatically. Here I am taking clear-cut example just to make you understand the incidences, because I am considering that you are still novice in Indian polity, and from that consideration I try to teach you Indian polity. So if I don't take the practical example, you won't be able to understand. So this naming of the party that I keep doing, right, that naming you should never ever indulge into, right? So that is the thing, again with that caveat. So until this Uddhav Thackeray dialed Prime Minister, right, that point was not settled, and as soon he dials Prime Minister, thereafter his nomination to the Legislative Council is cleared. So what was that indication? Means whatever communication that was to happen, right, that was to be happen in between this Council of Minister and Governor, right? There was not need of introducing the role of Prime Minister at the political level, right? This is disrespect of federalism, right, where you are compelling head of a state to settle the political points from Prime Minister at the political level. This is not a political question, right? So that was nothing but the amount of control that center does have over this office of governor, right? So that was because of this. So that is nothing but a case of misuse of power. So governor hesitancy in accepting the recommendation of the cabinet for the nomination of Uddhav Thackeray in Legislative Council of Maharashtra. So this is the first and most recent case of abuse of discretionary power, right? Because although this was not a discretionary, the accepted practice was that Council of Ministers would, in such cases, in cases of nomination to the Legislative Council, so you do have 6 states, I have repeated it earlier as well, so you do have 6 states where you have Legislative Council, and in this Legislative Council, governor does have power that he can nominate 1/12 of the member of the Legislative Council through nomination, and this nomination, who will be nominated, generally this is suggested by council. So that has been the accepted practice. So that was not the discretionary power, but that could have been appropriated as discretionary power by the governor because of, if you remember, Article 163 second portion that said that whatever be the discretionary power of the governor, that will be ultimately decided by the governor itself. So that could have been appropriated, but that was not the, again I am saying that that was not the political practice that governors of the different states have opted for. They have generally abided by this practice, this custom. So I hope this abuse, this particular case of abuse of discretionary power would be clear. Next, see another case of abuse. So here you will have to understand the sequence of event in the Maharashtra in 2019 when the election happened. No party attained the clear-cut majority. BJP was called in that, hey, can you form the government? BJP in the first instance said that no, we cannot form the government. Thereafter, you had this NCP was called in. NCP also said no. Thereafter, Shiv Sena was called in. And Shiv Sena also said no. In the first instance, INC was not called in. Thereafter, when every party said that no, we cannot form the government, we cannot form the government, thereafter president rule was imposed, and that was rightly so, because when no party is forming the government, right, president rule would be imposed. So president rule was imposed. Now suddenly on one particular night, so in between there was a gap of this 10 and 15 days, discussion was going on between Shiv Sena, means continuous discussion about the seat sharing and ministerial berth sharing. So discussion on this ministerial berth sharing was going between Shiv Sena, NCP and INC. So that was delaying the process of formation of government. Now, as soon they were about to close this deal, and there was clear indication that within a day or two, this particular formation, because they had already named their alliance as well, MVA, Maharashtra Vikas Aghadi. So once they have named their alliance and once they have finalized their common minimum program, CMP, common minimum program, that okay, this will be the agenda and this will be the vision of our government, on these basis we are forming the government. So there were clear indication in the media that within 2 or 3 days they are going to claim to the governor that now we have reached to a position where we can form the government. So you remove the presidential rule and let us allow to form the government, right? Thereafter, one particular party orchestrated a plan whereby a defector of this particular party, NCP, within a night, means this happened after 10 p.m. so that when whole of the Maharashtra was sleeping, whole of the media was focused somewhere, means after 10 p.m. suggestion, this man colluded with this man, right? And again, there is allegation, there is wide amount of allegation, I am not saying anything, right? There is wide amount of allegation in the media circle that this was the thing that would have gone in, right? So I am not sure about this. So around 10 p.m. a ruling party in the Maharashtra suggests governor that you withdraw this president rule. President rule's recommendation, removal of the president rule revocation goes from governor's office to Central Ministry of Home Affairs. From governor to Ministry of Home Affairs at the central level at around 11 to 12 p.m. See the efficiency of our ministries, right? Thereafter at 5:47 around, 5:47 a.m. I am talking about. See how bureaucracy is efficient in such political matters. At 5:47 MHA sends to the governor's office a fax कि president rule जो है state में से वो हट गया है. Means we have approved your request of revocation of presidential rule. And around 7 a.m. you will see that these two people, he as chief minister and he as deputy chief minister, takes the oath within night, right? So from 10 p.m. to 7 a.m. next day, you had a new government. Means from last 1 or 1.5 months, there was wide amount of this tussle going on, no government formation, and as soon the other party, opposition party, has cobbled up, they have numbers and they're going to claim the government formation, you will see that within this 9 hours you have a new government in place, and that new government was of the party that you do have in the center, right? So most of the time, another incidence if we see, so this was nothing but again a misuse of discretionary power, because if you connect the dots, right, how is it possible? Does our ministry, does our bureaucracy works in night in general situation? No. So how can this bureaucracy at the central level and state level works? Because if at 7 a.m. if these people are taking swearing in, right, in the governor's office, the preparation would have started at 4 a.m., right? Because if the formal, they have to take formal swearing in, right? There would this whole of the staff at the governor's office would have done some kind of work, paperwork would have gone on, right? There would be clerical work that would have gone on. So whole of the night this governor office and Ministry of Home Affairs was working on. So this is again nothing. This is abuse of governor's power. If you see another incident, so in 2018, if you see single large Karnataka example, so Karnataka had gone into the election. Here no party had been able to secure the clear majority. So there was talks going on between JDS and Congress. They were ready to form the government. In a day, they were about to stake the claim for the government formation. But then BJP, led by Yedurappa ji, they claimed the government, and this party, BJP, was called in. Ki bhai aap, they were invited ki bhai aap government banao. Rather, he was sworn in as CM as well, and 15 days long time. So see, this is not the objectionable thing. Single largest party was called in, no issues. See, the parameter or the determining factor in the governor is that whether you are calling single largest party or you are calling coalition, right? What it should be dictated by? It should be dictated by that which party, either single largest party or coalition, can give the stable government for next 5 years. So doesn't matter if in opinion of the governor or the president at the central level, if the coalition can give a stable government, he can call the coalition and he can ignore the single largest party. But if in his opinion, in governor's opinion, if single largest party is in condition to form the government or is in position to give a stable government, then he can call. So there is no issue that whether he is calling single largest party or the coalition, there is no issue at all. The issue arose at when 15 days long time was given. Now the situation here was that this JDS Congress collectively had the numbers, and there was no way that BJP could have been able to manage the number, the required majority, without defection from the JDS plus Congress. Right, and that defection, there was every possibility that if this much time you are giving, right, there was every chance that there would be horse trading. So by giving this much of time, means reasonably 3 to 4 days time could have been given, and thereafter this party would have been invited. But that stand was not taken, and 15 days long time. Ultimately, Supreme Court, these two parties went to the Supreme Court, and this 15 days was reduced to 3-4 days, and finally Yedurappa ji had to step down because he could not seek the confidence of the House. In 2017, if you see, Manipur and Goa had gone into the election here. So here single largest party was called in, but here Congress was single largest party, but Congress was not called in to form the government in both the cases. Here BJP was able to manage the numbers to get the coalition, and here in the opinion of governor of these two states, here Goa it was Miradullah Singh, and Manipur I don't exactly remember. So here in governor's opinion, coalition was more in condition to give stable government. That was the explanation that had. But in both the cases, if you connect the dot, both the cases seems to be favoring the ruling party in the center, and that has been the pattern. See, I'm not questioning the wisdom of the governor. Does not matter whether in this case what pattern did he follow, in this case what decision did he take, that should be dictated by his wisdom. But the problem arises when his wisdom is not independent, means when his wisdom is being dictated by his control measures on the term and the method of appointment, then the problem arises. So here the wisdom is being compounded, the problem is being compounded by control over his office term and plus appointment method. So that compounds the problem. And when you connect the dots, right, not only in this, means just to balance this thing, right, so it is not only the tenure about this particular ruling party. In past as well, this has been the instance where the decisions of governor, if you see, most of the time, not all the time, I am not making any sweeping or generalizing statement, but most of the time governor's decision has helped in one way or another the central ruling party, right? And this has started, means this is not the recent case. If you go back to 1956 too, you had this first suspension of C. Rajgopalachari was invited. So C. Rajgopalachari, who was freedom fighter, in 1952 itself, when you had this government formation in TN, Tamil Nadu, the Congress did not have required number. The other party, the other side had the required number, but the Congress was called in to form the government despite their leader C. Rajgopalachari was not even MLA, right? So this discrimination had started, or this cases of misuse of governor office had started immediately after independence. In 1956, you had this first application of 356. Kerala government ruled by the CPI was suspended by the central government, right? So that was one area. Now if you see another few cases, and these cases, why these cases occur? These cases, as I already told you, why governors has not been able to function independently, because of control over their term and control over their appointment, right? Control over appointment and control of term. And result of this control is that there has been wide amount of allegation of interference but in the opposition ruled state, especially regional parties, जो है, be it TMC, be it YSSRP, right, be it Telugu TDP earlier in Andhra Pradesh. So these regional party have most of the time claims कि भाई ruling party जो है वो जो governors appoint कर रखे हैं वो जो decisions. So you have this continuous tussle going on between this Dhankar fellow in West Bengal and TMC, right? There would be a huge amount of friction if you keep noticing this political event, right? You will notice कि बहुत ज़्यादा मतलब वहाँ friction चलता रहता है. So it is because of that central government does have control over these two things, and it is not that the government ruled by the opposition only have faced the burn. It is governor as well that have faced the burn because of control over appointment and term. So if you see in 1989, you had this VP Singh government who had suggested all the governments appointed by the previous government, right, by the Congress. So Rajiv Gandhi led government you had in the place before VP Singh took the charge. So they suggested, this VP Singh led government suggested कि भाई आप resign करो. Finally, जब PV Narasimha Rao की government आती है, Congress led by PV Narasimha Rao government in 1992, you will see that in 1992 again, 1991, right, PV Narasimha Rao also recommends कि whatever governor, whichsoever governor had been appointed by VP Singh, they are also asked to resign कि भाई आप resign करो, otherwise we will terminate, we will suggest president कि आप pleasure अपने हटा लो, pleasure remove कर लो, right? So in 1989 or 1991, wholesale resignation. Recently in 2014 as well, if you notice, there were 7 governors appointed by the Congress UPA 2 that were suggested to resign. 6 governors willingly resigned, 1 was forced to resign. So NDA government nudges 7 governors to quit, 1 refuses. So the point was that it is not because of this control over appointment and control over term, it is not that only state government have suffered, these governors as well have suffered. Now what is the way out? If you want to find the way out, right, so the way out so there have been various committees and commission that has been instituted, not especially to look into the independent functioning ki inki independent functioning kaise ensure ki ja sakti hai. There has been like Sarkariya Commission when had been set up. Sarkariya Commission TOR, terms of reference, was to look into center state relation. ARC, Administrative Reform Commission का ये था कि administration को कैसे properly चलाया जाए, other aspects of administration. So there was not given the pointed or express terms of reference कि आप गवर्नर के ऑफिस को ही देखो, but they have given recommendation for the independent functioning of governor as well. So see, you need not to remember all the provisions that has been given by these commission from time to time. What you can do is that you can figure out ki problem kya hai. So the problem lies in, as I already told you, the problem lies control over term plus control over appointment. So whichever committee or commission that you will see, their recommendation will center around कि term पे जो control है वो remove किया जाए, their terms should be fixed and the way of appointment should be changed. Right now, what is the way of appointment? That central cabinet recommends it to the president and president appoint a person as governor, right? Most of the time either retired bureaucrats or political person, right, who have become aged and non-productive for the electoral benefit, those people are appointed to these office. Now the accepted practice should have been कि भाई चीफ मिनिस्टर से, जिस स्टेट में आप ये गवर्नर अपॉइंट करने वाले हो वहाँ के चीफ मिनिस्टर से पूछो, right? Plus to make things more inclusive, what can be done कि स्टेट लेजिस्लेचर तीन चार बंदों का, तीन चार पीपल का एक रिकमेंडेशन दे सेंट्रल गवर्नमेंट को, एंड आउट ऑफ दोज 3-4 पीपल सेंट्रल गवर्नमेंट शुड रिकमेंड प्रेसिडेंट टू अपॉइंट एनी वन पर्सन. और थोड़ा सा और इंक्लूसिव बना के क्या कर सकते हैं कि स्टेट लेजिस्लेचर और द स्टेट गवर्नमेंट विल रिकमेंड नेम ऑफ 3-4 पीपल, एंड देन instead of only central government recommending to the president, what central government can do is that it can include leader of opposition, then vice president, and one more neutral body can be included, and finally this body will seek in out of these 3-4 people who should be appointed, and then recommendation should be given on the advice of these 3-4 people to the president. So you will see that the recommendation of all these commission will center around कि term को जो है fix करो, कंपेलिंग सर्कमस्टेंसेज में ही इनकी सर्विसेज टर्मिनेट होनी चाहिए, इवन दोज कंपेलिंग सर्कमस्टेंसेज नीड टू बी स्टेटेड, एंड अपॉइंटमेंट मेथड को कैसे चेंज करना है. सो रिकमेंडेशंस ऑफ दीज वेरियस कमेटी, ओनली सरकारिया कमीशन की रिकमेंडेशन इन रिगार्ड्स टू द गवर्नर इज लिटिल लेंदी. एज फार एज अदर दिस एडमिनिस्ट्रेटिव रिफॉर्म कमीशन, राजमनार commission, then Venkachalaya commission, then you have this Pucci commission in 2008 which was established in, right? So their recommendation about this governor's office are 2 or 3 lines. So I'm not going to read all this because they are plain simple. There are no linkages or there is no analysis that is needed. Those are completely factual. So slides that or the PDF that you will get will contain all these things, and I'll expect you to simply read it, right? So ARC first the two recommendation that ARC first has given in this regard are these two. Then you have what you call ARC first recommend. Just a moment, the heading should have been, I guess, changed. Whose recommendation is it? I guess this was of Rajmanar. Just a moment, Rajmanar. I'll have to correct it, right? So Rajmanar recommendations. Then you have the Sarkariya commission. Then you have this Venkachalaya commission, and then Pucci commission. So what has been their recommendation, right? So these are the recommendation that various committees and commission over a period of time has given about to remove whatever difficulties that governor's appointment method or governor's term does have, right? So I'm wrapping up this lecture here itself. We do have 4 or 5 MCQs. Rather important articles that you must remember. Again, I am suggesting that although whatever article that has been mentioned in the Lakshmikant, if you have capacity, right, not all the article, but at least 50 to 60% of the article, if you can manage, right, you should remember, but if you cannot manage even those 50 to 60% of the article, these are the most important article that you must remember. You cannot take luxury कि मैं इसको थोड़ा सा छोड़ देता हूँ, ये इतना important नहीं है, ये इतना important नहीं है. That kind of things you need not to do. So these are the articles which are most important. Now entering into MCQ. So there are 5 MCQ that has been put up. First, second, third, fourth and fifth MCQ. So these are the 5 MCQ. So with this lecture we are wrapping up the governor's lecture. Next lecture would be on Chief Minister. So till then, bye bye.